So today I would like to introduce David Bennett, who is our IP counsellor in China. David is joined by Charles Feng, who is a partner for East and Concord in Beijing. So David, please, over to you.
Thanks, Casey. I'll just briefly introduce myself and then we'll launch straight into the content. So I've been here at the Australian Embassy in Beijing representing IP Australia since 2016. My position is here, broadly speaking, to help Australians to protect their IP in China. Just going to turn the webcam off to not distract from the slides. So I do outreach work, I give assistance and support to businesses, and I also support our government-to-government engagement and IP policy in relation to China. The practical things I do really help identify things that need addressing at the policy level, and that's where it's also very useful to have information and feedback from Australian IP attorneys and lawyers, so please reach out to help identify issues that need addressing at the policy level. I give guidance and support on specific inquiries based on my experiences with other cases here in China, but I don't give legal advice or legal services, and I always steer businesses towards Australian IP attorneys. Our web resources linked here, ipaustralia.gov.au/China, are intended to be very practical and useful. We're currently working with an IP firm to develop new materials, particularly on contracts for China, and also on research, collaboration and commercialization in China. That should be up in the next few months, so do check back. My objective of this webinar is to help Australian trademark attorneys to better represent Australian clients in China. I've done webinars before, but I thought I would enlist a local practitioner along to share on-the-ground experiences in China, which is where Charles comes in. So I'll pass to Charles in a second. He's partner, also co-head of the IP department at East and Concord, a firm right here in Beijing. So Charles, I'll pass over to you.
Thank you very much. Thank you very much, David, for your very kind invitation for me to give me the very precious opportunity to communicate and share my information experience with our Australian colleagues. Basically, I'm working with East and Concord, which is a large Chinese firm, has more than 400 lawyers across China, and headquartered in Beijing with branch across China. And I myself probably joined the firm. I used to work with Baker McKenzie and with other large Chinese law firms to join it. And my major practicing areas on IP litigation as well as trademark prosecution matters. So, I have been helping clients from the US, EU, Australia, Japan, and other Asian countries in order to protect their trademark and other IPs in China in the last 2 decades. And also, I of course have experiences in working with Australian law firms, IP agencies in their IP matters in China as well. So today we will discuss about trademark protection in China. So my presentation today will incorporate about 5 parts of them. And first, we'll give you the very basic introduction on scheme of IP protection in China. Second, we'll be focused more on the trademark application and prosecution matters. And then we'll discuss a little bit about protection, IP enforcement, trademark enforcement. And the last, we'll also touch on a little bit on the new issues like OEM updates. And the last slide of mine will be on the recent trademark law revision. So first of all, the main problem for your trademark protection in China, first of all, you got to be in your mind is about the China is a law. The Chinese trademark law provides Article 30 and Article 31, which provides the people who has been firstly filed the application of trademark with identical similar kind of goods will get the trademark registration, which we call the first to file doctrine. The first to file doctrine was first to file principle, give the people more incentive or more advantages when they register the mark firstly in China, other than using firstly in China. So this kind of law doctrines have given significant results in China. Is that in recent 5 to 6 years, the trademark application, the number of trademark applications in China and registration number in China has dramatically increased. If you go to the slides, there's a graph that expressed the recent jump of the Chinese trademark, the number of trademark applications. The latest one was 1970, it's about more than 5.7 million trademark registrations has been filed just in one single year. And what I know is that in 2018, the number had jumped another 23%, and currently it has about 7.3 million in just 2018. In the 1 year, it has this kind of number. So presumably, this kind of, and also we got the number from the TMO is that the total number of valid registration trademark has exceeded 30 million. So this kind of number is amazingly and surprisingly large. So what we can learn from is that apart from the portion that is a reasonable reflection of the Chinese economic development, a very large portion of them actually reflects the loophole of Chinese trademark law, which means you have a large number of preemptive registrations or Paris who is registering the famous brand of Chinese and famous brand of foreign companies without authorization from the brand owner. So this will come to another problem is that when they register your number or they didn't register number, they will go to manufacture or distribute infringing products, which is called counterfeits. So the counterfeits come to China in different levels and different channels. First, will come through the retail level or go through the wholesale market. The second will be more significant in recent years on internet sales of those products. And also you go through the geographically, Zhejiang and Guangdong means two hotspots areas where people find most of the counterfeits. So all of this I discussed will be reminding people in Australia that you got to know in China. The first thing you think about when a client want to come to China is to do the trademark filing. And the PRC, ironically, the people say it's a priority country for filing, which means that even you do not have a local distribution in China, or you even do not have a plan in your mind to do the local distribution in China, you got to think about the filing of your trademark. Otherwise, if the people get the personally registered mark in China, you will have more trouble than you actually should have. The second would be avoid infringing others, which means that if you have the trademark registered in China, it will give you a lot of advantages. The first is that you refrain from you to infringing others' trademark. Because according to the judicial interpretation issued by Supreme People's Court in 2029, the judicial interpretation tells people that if you have registration in China, then the other registration owner of the other trademark registration will not be allowed to sue you on the basis of trademark infringement. Therefore, if you have registration in China, which will help you to get rid of the risk from infringing others' mark. The last will be the preemptive registrations, with people in China, bad faith registration from time to time to use the preemptive registration to seek forced marriage, which means that they first to have the economic cooperative relationship with you, the real brand owner in Australia. The second would be seeking serious compensation from sales and marks. Just as before, where I will illustrate a little bit more in the latter part of my presentation today. When the people register your mark, preemptive register your mark in China, when the real trademark owner sells their products in China, they will face the risk of being sued or being ordered to compensate the preemptive registrants. So this also comes a lot of problems, and the new trademark law revision also tells people about this.
I was just going to add, I saw this forced marriage thing talking about recently, just assisting someone in it just a couple of weeks ago. Exactly as you say, it's the first time I've heard someone use this term forced marriage, but that is exactly capturing what is going on here. I think Australian attorneys would be very familiar with seeing people seeking compensation for marks. And the other thing I've seen is, as you say, a defence against infringement, so that people can produce their own IP infringing copycat goods and use that as a defense.
Absolutely. And when we go to the more fundamental things, first of all, if you want to register your trademark, you got to know what can be registered trademark in China. Traditionally, the people want to have their logo or the letter of the mark we register in China is very easy to understand. But Article 8 provides the people say that any sign that distinguishes good of an entity in China from others will be allowed to be registered as a trademark. This will include word, device, letter, number, dimension, style, color, combination, sound, and combination of thereof. So, first of all, in the old trademark law before 2013 to 2013, there's a requisite, there's a requirement of visible sign to be registered in China. But when the trademark law was revised in 2013, it gave it more addition on the sound mark. So currently, any perceptive sign can be registered as a trademark. So this gives you a huge room for the new type of trademarks. For example, what we call the non-traditional mark. In very recently, there's a case in Beijing High Court ruled for the France shoes manufacturers Christian Louboutin with the trap. The court ruled that a solo color mark being used in fixed position does also fall into the possible scope of subject matter that possibly can be registered in China. So the Chinese court and TRAB does not have an exclusivity for the scope of subject matters. We give the people more room in the future to challenge, to try their new type of trademarks for their trademark application in China. But of course, if you want to register your trademark in China, the one of fundamental requirement of the distinctiveness. So Article 9 provides that any distinctive characteristic of identification can be applied for registration, but it should not be completely trivialized, of course. And Articles 11 provide that the signs got to be distinctive, which means that there should not be generic names or device or model numbers. And also they cannot be descriptive, which means that the marks cannot be a simply indication of the quality, main material, function, use, weight, quantity of other feature of the goods. And also it gives more other marks that lack distinctive characters cannot be registered as well. So this fundamental requirement for the signs to be registered trademark as long as they're not generic ones, and also they got to have the distinctiveness to be proved at the Chinese court. In particular, when it goes to non-traditional marks. And the second one would be the paragraph 2. The signs refer to the preceding paragraph in the registered trademark when it has acquired distinctiveness. This means that under the trademark law of China, similar to other common law countries, if a trademark acquires their distinctiveness through a long term of use, and then it also can be registered in China as well. So intrinsic distinctiveness means that when the mark has their intrinsically be different from others and easily identified as a sign of trade and a sign of an identifier of the manufacturer or distributor, then they can be registered as trademark without any question. But for the non-traditional marks, if you go to the dun 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 dun, that's into music or sound, or it goes to the green and yellow color of John Deere, or if it goes shape of the letter of Zippo, then also they can be registerable potentially serapically in China as a non-traditional mark as well. And also the bottom of the perfume or the bottom of a drink can also possibly register as a mark. So from my slides, I introduced a few very important cases in China before that has already been recognized by Chinese court. One of them is on the Zippo letter, which I have been get involved in person, where my client wanted to register the shape of the Swedish shape as a trademark in China. We fight with the TRAB at the Beijing #1 Champion Court, and then the Beijing High Court. We got a final decision with Beijing High Court that the shape of that letter is distinctive and can be registered as a trademark. And then the mark has been preliminarily approved, and it goes to the opposition proceeding and has not been settled down from that phase. Second case I want to introduce is about this high heel case, Christian Louboutin. Probably you already heard from the Chinese court, if you have experience working in Chinese IP matters before, that the court ruled, as I mentioned, it's got to say that a solo color mark being used in fixed position can be trademarkable as long as it provides sufficient evidence to prove the distinctiveness. But the Chinese court in this specific position, the Beijing High Court mentioned that a solo mark cannot be, at least it cannot be excluded just because it includes just one color of red.
So I guess on the non-traditional marks, my experience has been that China is probably a little lagging behind other jurisdictions with respect to non-traditional marks, but there's been a couple of these key cases recently, the Louboutin, the Dior perfume bottle. So it seems like foreign companies can see traditional, non-traditional marks, but it may perhaps they're not going to get that in the first instance at the trademark office or at the TRAB, and they may have to be taken to the courts before they're going to win those cases, do you think?
Yeah, very correct, David, that in China, the traditional mark has never been an easy thing. As you can imagine, when the people you got to get through all the obstacles on how to prove the Chinese authorities about distinctiveness. And secondly, will be that when you go through some very important trademarks that can be in a conflict of interest of the other Chinese competitors, it will also face a lot of local difficulties, understand political things. But in any event, the Chinese authorities as a whole is more advancing in this aspect, which means that it has been more flexible than ever in order to grant registration for this kind of marks. Yeah, there's no doubt. And non-functionality is another requirement which means that if you want to apply for registration of a trademark, you definitely need to refrain that your mark is actually oriented from any functional, technical, or other substantial value from that size. Otherwise, it could be rejected to be registered as a trademark. So basically, if you want to get rid of the risk of this, the first thing for the applicant you've got to think about in your mind is that do not try to protect any subject matter covered by patent, in particular, any patents that's among the technical features. The second, do not protect subject matters that you actually advertise as providing functional benefits of your products. So if you have more introduction on the functional feature of your shape, of your design, of your trade dress, then the more difficulty you will face when you want to register as a trademark. So we go to more fundamental things about the trademark application, the procedure thing. First of all, in China, we have an application and class which are very similar to other countries across the world. We're adopting the NIST classification. And NIST classification, the trademark office also issues their classification list, which almost copy the NIST classification, but also it has very slight adjustment on very detailed products, on detailed customer goods in a small group of things. But basically, China has two kind of application. One is we call one application, one class, which means that you file one class, one application, then you got to appoint one class of goods that you want to cover in your registration. The second would be one application covering multiple class. So this comes up to the revision of 2013 when the new trademark law allows the people to register one application covering multiple classes of goods. So however, in terms of the fees, in terms of any application fee, official fees obtained by the TMO, actually there's no any differences. So actually when we file the application for a client, the people are more prefer to do the traditional things, which means that they more prefer to do the one application, one class. In order to, otherwise you have multiple classes, you will face more problem in the second stage of your application. This comes to the questions addressed by one of our Australian colleagues, the retail service and color certified. So as you understand, the color certified covering a whole bunch of services, including those like promotion of products or promotion of services and others. However, in China, the people in those industries, like retail industries, they did not find appropriate class of services for them to apply for registration of a trademark. So very recently, in 2016, there is a very milestone case ruled by Beijing High Court called Wanse versus Trap. In that case, the Wanse is an applicant. It has been applying for registration in class 35, and it's wanted to provide to maintain the registration in the class 35 by providing the evidence to prove the use of trademark in the provide assistance to the operation and management of commercial enterprises or assisting business activities or administration business functions. However, in that court decision, the Beijing High Court clearly ruled that the evidence with regard to the service of supermarket, to the evidence on the services regarding to the distribution services will not be recognized, will not be held as a kind of services provided in class 35, which means that their trademark has been diminished by the trademark because due to the non-use of 3 years. So it reminds people that actually in China you do not have a appropriate class of services covered for the registration of your supermarket and other retail services. So this comes to the problem that under the current trademark, there's no actually a resolvement to this issue. However, when you want to have this kind of problem, for example, the Walmart is a famous supermarket service mark. We understand the Walmart register is very broad of their trademark application, the trademark registration covering a whole bunch of services in class 35, from 35.01 to 345, or almost every single subclass of that class has been registered. So this reminds people that in China, because there's no appropriate one for registration, the people have to do a more broad application to covering almost every significant subgroup in class 35 in order to maintain the trademark registration. But whether this is enforceable or whether this can be challenged due to the 3 years of non-use, as I mentioned earlier, Wanse case is still questionable. We believe that this will be settled in the future, but at this point of time, there's no clear rule that can settle this issue. And the only way that people want to adopt is try to apply as much as they can, and then they probably have to reapply in every 3 years in order to maintain the registration in those class of goods.
Thanks. I'd asked you specifically to talk about this class 35 issue because that's an issue Australian trademark attorneys often have in China. When we were talking about it, you'd also mentioned one thing which I've been seeing as well, which is Alibaba Tmall stores actually requiring, in some cases, a registration in class 35 before they would give a license for an official store to a foreign business. Could you comment a little more on that?
Yeah, thank you for mentioning this, David. Actually, as you just mentioned, that the Chinese e-commerce platform, including Alibaba and Tmall, as far as I know, they have a very specified internal rules that are requiring the owner of online shop to provide evidence that they have a registration in the same class, in the registration class 35. And therefore, this reminds a lot of people in China when they want to open their stores on the online platform, they first go to the Chinese trademark office to register their mark in class 35. So it gave a huge incentive for the registration in class 35, but it also have a huge disadvantage for foreign brand owners. Even they are in any other industry and they have already got registration in other class of goods. For example, they have a registration class 9 and actually did not have intention to registering their trademark in class 35. But the people in the retail industry, they went to the online shop and then they first register your brand in order to get their products being sold on the platform. And then this kind of people was the first. You can see through the trademark law, trademark office database, there have a huge number of registrants who actually have registered a lot of famous brand in class 35. So the reason we want to mention this is the brand owner, or trademark colleagues know is that first of all, if you or your client want to do business online in China, probably they want to think about the registration class for 35 before they actually entering that field of market. The second is that even you do not have the intention to do the class 35 business, you have still want to think about the registration in that class of goods. Otherwise, the Chinese competitors or preemptive registrants, they may probably go before you to do that, and then you got to spend tons of resources in order to resolving that in the end of the day.
Yeah, very important to know.
Then we go to the very general procedure of trademark law registration, and you can see from this graph you got application filed, and then there will be a preliminary examination done by the trademark office examiners. Then your mark will be preliminary approved. If there's no any prior marks be identified by the trademark examiner, and then you have a 3 months term of opposition. And if there's no opposition filed by any relevant party in China, then your mark will be finally registered with the trademark registering the Gazette. And also, if the people want to challenge the already registered mark, they can go through the procedure of invalidation. And then when they go to invalidation, the decision made by TRAB is a final one at its administrative phase, but people still can challenge the TRAB decision with the Beijing IP Court and finally with the Beijing High Court. And the Beijing High Court is a final decision maker in China on any ownership, on any validity issue of the trademark. And then, of course, we have a Supreme People's Court who has a specific procedure for retrial, but that number of the cases is very limited in general in China. And then we go to, if you want to register your mark in China, what should you do? First of all, you got to figure out what exactly is the current portfolio of your clients and what's the exact business needs of the clients. So what we are advising our clients to do is, first of all, your main brands in China is a must to be registered. The second is a mark that your mark has already been used in China, not registered. You got to think of registering as soon as possible, because once your mark's used in China, you have more exposure to Chinese consumer and to Chinese competitor and to Chinese pirates. They have tons of intention to register mark without your authorization. The third would be the application of defensive trademark. This means that when you have the registration in other class of goods, for example, you have application in class 9 when you're doing the home appliance products. But in other class, as I mentioned, for example, in class 35, if you do not do the application in that specific class of services, and the people may go before you doing so, and you have a lot of problem to deal with that in the end of the day. So what we're suggesting to clients is to think about to do some defensive trademarks. It will be more it benefits to you in terms of the cost-effective way. The next one will be the trademark use in other countries not registered in China. Because the international business has been growing so fast, and the Chinese competitors, they have a lot of knowledge of foreign brands. And therefore, if you have a very famous brand in Australia have not been accessed to Chinese market, does not necessarily mean that Chinese people does not know your brand. Does not mean that they do not want to register your mark before you come to China. So it's also give you a lot of problem when the people came to China later, or they came to China and to see whether they want to use their mark and they found their mark already be registered by other people. And the trademarks facing serious duplication and imitation is very understandable. If you already have a Paris or counterfeiting problem in China already, then there's very high possibility that your mark has already been registered by some other people in China already. So how to do the search? How to do the trademark registration? The first thing you want to do is do a trademark search. The trademark search can be done in different ways. The most fundamental ways, you go through the TMO, they have online database for you available for the people to go through. The online database is available on 24 hours, 7 days a week. And you can go to the linked website below, and then you access to the Trademark Law database. It has different functions to go through the word. They have the search capacity to do the search against English mark, Chinese mark. But if you go to the more device marks, you have more difficulties because it will require you to do more technical analysis and give them the number of identifying the different shapes. Supplements the TMO official search and search wiper database. And this has been done before, but recently there's less people, decreasing number of people doing this. But more they rely on other professional database provided by Chinese companies, including one we have been used like Baitu White Rabbit and others from Shandong province and other trademark search engines we have been using in China. That is chargeable. It's not free. It's chargeable, but it's more accurate and more updated than the official ones.
On this, we've on our IP Australia resources, I wrote a guide for searching the Chinese trademarks register, which explains a bit more about how some of the functions work. So do have a look at that. It's the only English language guide to the search process that I'm aware of. Just in the past couple of years while I've been here, when we started out, the database was terrible. It was so hard to use, it frequently went down, but it has improved greatly in the past couple of years. It's actually fairly reliable now. It can be sometimes difficult to access from Australia, from outside of China, but if you find the website down or something that persists.
One single issue I want to add here is that you got to bear in mind that available TMO database from its official site, as I mentioned in the slide, is that it have a kind of lagging behind accurate information about 6 months, which means that in the last 6 months, the date may not be recently updated. So, which means that the best thing we can do is go through the database and find the results, but the results may not include the very recent information has been submitted to TMO in last 6 months. This is a problem. This can not be solved at this point of time. But the best thing is what we're doing is that we can go through any professional database that if we can do. Yeah. I think this has already been discussed in the last slides, but I want to let you know the Chinese translation of the trademark is also very important. The foreign brands is English mark, but not a Chinese mark already considered or applied in China. That you got to think about that. Otherwise, the people in China, they may do a lot of registration about the transliteration of your trademark, or the Chinese people, when they got to know more Australian brand, for example, they have their own name in their mind, and that name can also be possibly registered in China as well. For example, the Vigra has a Chinese brand called Weiger, grandbrother, that has already been registered by Chinese people. And then when Pfizer came to China, they found that mark be registered and had a lot of difficulty to get rid of them. And another will be technical things. When the people want to do the trademark registration, the question would be if you want to register as an individual one or you want a combinated one. So this also come to different angles to think about. First of all, the individual trademark has its own advantages. First of all, it possibly have less obstacles if you want to do a research, you will be able to know that you have less obstacles when you go through the single mark search. And also it has more flexible in use. But also it has a lot of advantages in, for example, in judging trademark similarities with combination mark. And also have an advantage in fighting against the trademark counterfeits. However, for example, in the left-hand side, you have a Mr. Muscle. It's a brand, the registered trademark in China already. And the right-hand side, you have a combination of Mr. Muscle and its Chinese translation, Weimeng Xiansheng Mr. Muscle, Chinese translation. So whether you want to register as a single individual mark or you want to be registered as a combination mark as a whole is a question. As a brand owner, as far as I know, in a lot of international brands, they will register both of them, which means that they will register the combination mark and the individual mark at the same time in order to maximize the scope of the protection. But from a professional perspective, of course, this kind of individual mark will give you more large scope of protection, and of course, it will have more possible obstacle when it comes to the people. If they have already registered this combination mark already, there will be obstacle blocking your registration in individual marks. So basically, the simpler the mark is, the easier they can be, the more difficulty they have to register. However, they have a broader scope of protection and when they face infringements. So another thing is that you want to remove the potential things. If you have figure out a prior registration already be in place without your registration, the most simple or the most important remedies you want to seek in China is that you do the filing of non-use of cancellation, three of non-use cancellation. As far as we know, in China, there is a very relatively high ratio of win in filing the non-use cancellation due to the reason I just mentioned. That China, the number of trademark has been so huge, and quite a large portion of them actually have not been put into use, actually. So when you file the non-use cancellation against them, there is a relatively high ratio of win in the end of the day. The second, if the mark is actually in use, then the brand owner will go to either the Chinese authority to invalidate them, or they have to go to the trademark owner to try to buy them. So negotiating trademark assignment in case of larger legitimacy is that in China, what we are doing in China, the ideal or the best practice in that area will be we're using the third party approach, the targets, in order, first of all, to ensure that the old trademark owner does not offer a surprisingly high price. So using the third party, unknown third party, in China, basically a Chinese company, for example, Chinese trade company, they get in touch with the trademark applicant and start the negotiation and discussion with the trademark owner. It will be easier for the international brand or international foreign lawyers to come directly to the trademark owner, because the latter will remind the people there is like the deep pocket came to them, and they will sell you a very large price. The second is that we ensure the assignment in line with Chinese trademark law, which means that there are a lot of license has been taught to the foreign brands that the international brand, they want to do the international global transaction. They do global assignment of trademarks as a whole, which may be multinational, multi-jurisdictional, including China, Taiwan, Hong Kong, or Southeast Asia as a whole to be assigned at once. But what you want to know today is that contract does not mean you already have your mark in China be transacted, because any transaction made in China on trademark got to be approved by TMO individually. Otherwise, any contracts you have is just you have the remedy from the contractual aspect. Does not mean you have a property on that trademark as essential. The last one we want to close is that never disclose commercial projects before obtaining assignment. The same reason I mentioned in the first reason I mentioned in this slide is that if you disclose a commercial project before you obtain before you obtaining the assignment, and then the Chinese registrant may offer you a huge price and surprise you and makes the transaction impossible, or will let you pay a very large cost that should be avoided. And yeah, this be a more basic things. English marks, the Chinese marks, is a must. You want to select earlier than later, and then you want to search and file them. Labels, 3D marks, product designs all should be considered as a whole if you want to have the trademark strategy, including China. So trademarks database, 30 years, 6 to 12 months, at least, I think at least, because more Chinese parrots, they're filing tons of trademarks identical, similar to yours, without your association. You got to file the opposition against them timely, because this is the cheapest one if you want to secure the mark. Investigate applicant to verify the use bad faith. And this will be helpful when you file the opposition in China. And access benefits buying marks from the parrots. This means that from time to time, the international brand, from the angle of saving the cost, they go to the Chinese parrots or go to the Chinese registrant, preemptive registrants to buy the mark. But this is not successful in any case. Sometimes it's not doable, or the price is too high. Negotiation, we have a lot of experience in negotiation and obtaining the trademark from the Chinese parrots and the prime registrants. And this can be done by Chinese professional Chinese lawyers. Madrid national. This came to another question listed by David to me. The Madrid national is also very, both of them are very important in China. So how to choose? How would you like to choose to do? First, you got to bear in mind that Madrid is cheaper, definitely, if you want to have a multi-jurisdictional application to file at once. As you understand, the Madrid has a cheaper price or cost if you have this multi-jurisdictional file at the same time with the WIPO. However, it also has a lot of some disadvantages. The first is that it needs more time than the national applications. As far as we know, it needs more time for 18 months or even more if you want to have your Madrid application be registered in the end of the day. The second would be irregular name of the user service may pass and may be registered. This means that the Madrid application, because it comes from the international list classification, and however the WIPO has its own rule in order to approve for the registration of trademarks. Therefore, it allows a lot of international brands to register the name of goods more specifically and more in line with their original domestic registration. For example, you have a registration in Australia already. You have goods and services, and if you go to the international registration in Madrid, then the name of goods may very likely be maintained from that channel. However, if you go to the Chinese national registration, you got to follow with the Chinese list of classification, and the Chinese list of classification will have more rigid rules in terms of the name of the goods, and the people want to adjust and want to revise the name of goods when they're not in compliance with the Chinese list. We have been helping clients to do this on a daily basis, and most of them will be get through and register in the end, but it takes a lot of energy and time in order to communicate with the clients and get them to be in order. The last will be advantages to the Chinese national registration is that the national registration currently handled by TMO, Chinese TMO, is quicker than the Madrid in general. In the last year, the declared period of time by the TMO of China is at about 8 months. They want to have the mark to be firstly preliminary approved and possibly registered. But in terms of the Madrid, as mentioned, about 18 months or more. So you can see there's significant advantages in terms of time if you file a national registration than the Metroid one. We came to another slide as about one in terms of opposition validation against preemptive application registrations. As I mentioned earlier as my slides today, that there's a huge, due to the huge amount of registration in China, a lot of them actually filed in order to either free ride the reputation of foreign brand, or to occupy the market before you came to China, before you come to China. What we're helping our clients is get rid of them by filing the opposition or invalidation. So I want to briefly introduce about the major provisions in terms of the remedies you want to use in this kind of cases. The first one, the prior rights provision is in Article 30, 32 and 33 of the Trademark Law of China. In Article 33, it provides that any copyrighted logo, trade names, or personal name of celebrities or design patents, they can be used as prior rights in terms of opposing or invalidating the other marks or the other registration. The second would be Article 32.2 is that unregistered famous mark with certain influences. This means that any prior use of the mark, if you have mark not been registered in China yet, but it has been used in China for a relatively long period of time and a relatively broad scope of geographically, then you will be able to claim Article 30. I'm sorry, there's a wrong number. It should not be 33. It should be 32. I want to emphasize here. Then you can rely on Article 32.2 in order to get rid of this kind of preemptive registration or applications. The other one is per agent principal relationship. It means that if you have foreign brand, you have Chinese partners in China who help you to develop your business, but they have go directly themselves to file the application of your trademark without your authorization, then you can rely on this provision, Article 50, in order to get rid of this kind of application and registration. In our last trademark law revision and last enactment of judicial interpretation of the Supreme People's Court, the judicial interpretation has been expanding the application scope of this provision significantly, which means that even you have not entered the contract with your Chinese partner, but they have entered the discussion or pre-business discussion with you, and therefore they have knowledge of the brand. Then they go to the registration. They also can be applicable with regard to the Article 50. And secondly is that if the people the registrant is not directly your business partner in China, but they have a certain relationship like relatives, like on a personal relationship to your Chinese partner, then you can also possibly rely on Article 50 in order to get rid of the registration. So this also help the people to apply this article in order to help you getting rid of those empty registration. The absolute grounds is important when you come to unhealthy influences, public order, or which means the public interest in public order things. And order also is very important to apply the Article 44 when you have Chinese Paris who register not just one single mark of you, but also a huge number of trademarks of your brand, or even maybe include other brands, then you probably can quote this provision. The last one will be Article 7, this principle of honesty and trust. I can elaborate a little bit more in the latter part of the slides today. So lessons has been taught to foreign brand owners. For example, AirPatent has paid a huge cost about 7 years ago when they found their marks already been registered by a Taiwanese company or subsidiary of Chinese subsidiary of Taiwanese company. They register iPad mark in China. And when Apple came to China, the trademark registrant has filed litigation, I think 10 to 20 litigation across China against Apple. And also they have a administrative rated filed against Apple. And in the end of the day, Apple has paid $60 million US in order to get back the trademark. So the teacher very important lesson to the, yeah, go ahead.
I think that's a very interesting one as well, because it was the assignment that was not recorded. I think that's a detail that many of us know the iPad story, but I'm not aware of that detail. Now, I think we've been a little over ambitious in the content we're trying to cover today, so we're going to have to skim over some things quickly in the interest of time, but all the slides will be available afterwards with some more details and cases. I think on OEM, we wanted to do a quick update of the situation with OEM, original equipment manufacturing. The latest Supreme Court case ruled that manufacturing exclusively for export in China was not considered use of a trademark in China for infringement purposes, but it also depends on what the registration status in the destination country is. Trademark protection could be a topic in its own right, and that's perhaps something we'll look at doing in a future talk. I guess keep in mind that there are all these different levels of trademark protection in China, from administrative through criminal enforcement, also customs, and these can feed into one another. So Charles has got an example here with Colgate and Collage, where administrative enforcement and customs enforcement is gathering evidence that's feeding into civil litigation. But at the same time, actions are being taken in the DTMO against the other registration. In April of this year, 23rd of April, the National People's Congress passed amendments to the Trademarks Law. These amendments will take effect on the 1st of November 2019. So I guess, Charles, the main changes that are of note to Australian attorneys are that there is now provision that bad faith applications without intent to use, filed without intent to use, that's now grounds for opposition and invalidation.
Correct.
Talk briefly about
I talk very briefly with this regard that the recently revised trademark law of China. It's first of all, it added a later part of Article 4. Any application of trademark restriction maliciously not filed for purpose of use shall be rejected. And also, it have combined with Article 33 and Article 44 in order to quote this article as an absolute ground in order to get you to opposing or to invalidating the trademarks. So this, what does it mean to the trademark owner or the trademark attorneys in Australia is that, first of all, you will understand there is a new requirement on intent to use in order to, as a general principle in the trademark law. Second, if a trademark you find a bad faith application without intent to use, then you possibly can rely on the combination of Article 4 and Article 19 in order to file the opposition, and the combination of Article 4 and Article 19 for the invalidation. Combination Article 4 and Article 44 in terms of invalidation. So this is the new remedies available for the brand owners when you dealing with the bad faith application in China. Also on the same day of April that the Supreme People's Court issued a new judicial interpretation. It's gave a more elaboration on how to understand about Article 4. It provides a specification in different 5 situations when this article can be applied, which means specifically it has the registration of trademark identicals and various marks certain popularity, apply for registration of trademark identical similar to others, with high distinctiveness, and also the same brand. The third would apply registration with any other commercial sign other than trademark, which is the plural rights. And the first will be registration for any names, buildings. It's more relevant to the Chinese architecture or any real estate industry. And the last will be important is applying for registering a large number of trademarks without good reason. So you can see from this is that first of all is that in general the Chinese authority turned to the direction that it has more strict requirement against the bad faith applications when they do not have any evidence to prove their intent of use. So this gave a new rule, give them new method or new remedies for foreign brands when they want to get rid of these bad faith applications. We will see more on SAIC and administrative level. They have more provisions in the future to be released. But first of all, this is plausible, and this can be made full use of by the Australian colleagues. The last will be the plausible progress in terms of increasing the punishment against infringer. It's easy to understand. The amount of damages has been increased to 5 times of that of the statutory damages, and the statutory damages themselves per se has been increased to 5 million RMB than ever. So they also have a new rules that's also very interesting and important, is that they apply legal liability against both the trademark agency and the bad faith applicants, and also the people who are using the bad faith registration to litigate against other brand owner. So in the future, you will feel less the people who register not just the preemptive register mark, but also sue you in China. You can quote this article against it to file the litigation against him to require the compensation against them. Thank you.
Charles and David, I've got a couple of questions that have popped through, and I will invite more questions should anyone like to stay on the line a little bit longer. If you'd like to submit those questions through the question and answer module on your control panel. Talking about the content, the last block of content there, we do have a question that says, is there anything that can be done to improve the chances that a decision in a review of a refusal will be deferred while actions for removal or invalidation of cited marks are pending? This question has come from Alan's.
I know exactly the issue being talked about. So where say a trademark application has been rejected because of a prior mark, and they're challenging they're filing an invalidation action on that prior mark, is there a way that they can stay the examination of the original of their own application?
Absolutely.
While the invalidation goes on?
Very good question, very practical question. We face this a lot in our work as well. Basically, the TMO have their own kind of rules that if you have, basically, if you give evidence to prove that you will win in the validation, in terms of evidence, then there's a high possibility that you will let the appeal or the original application appeal and under administrative insurance application to be stayed there. The Chinese court and Chinese authorities, they want to see the evidence to prove that you're going to win. But if you do not have the evidence to prove that you're going to win the validation, they incline more, they incline not to stay, not to wait. And so the basic techniques that we're doing is that, first of all, when we do the appeal, this is almost impossible when you do the first filing, right? You don't have the room to do more evidence production and submission. When you do the appeal and the following administrative litigation, we want the Chinese court to know that we're going to win in the validation. We have enough evidence to prove that the prior mark will be validated due to a lot of reasons we want to elaborate. This is the first thing we want to let the Chinese authority know. Yeah.
Thanks.
Thank you very much. I have a few more questions come in, so I'm going to start from the top and hopefully they make sense. So the first one that we received is when we're talking about the combination marks, so I think the examples that you had on screen were the Mr. Muscle marks. If a combination mark is used as it is registered, that is both English and Chinese translation together on a product, is the combination mark vulnerable to removal for non-use after 3 years? Or is a combination mark treated as the same as a series mark, that is variation is separately protected, therefore if used individually will not be vulnerable to removal for non-use?
Thank you for the question. I believe that in terms of the vulnerability with regard non-use challenges, basically there's no substantial difference between the combination mark and the individual mark. The only difference they have, as I mentioned in my slides, is just on the enforcement aspect as well as on the prior search or prior obstacle aspect in terms of when you want to register your mark. But when they are registered, I believe they have the same sustainability against non-use challengers.
Thank you very much.
So Charles and I know people are going to have to leave in a second, where we can stay on and take some more questions. But just before people do leave, I wanted to note that we're planning the next webinar for 11th of July. Going to have Wei Xin from Yoming International talking about contracts for China. So one aimed at the legal profession more generally on contracts for China. This is the first webinar of this type that we've run here from Beijing, so we're keen to get suggestions on future topics and other things. So if you can answer that in the survey, that would be greatly appreciated. We're trying to find out what works and how we can share information here from China, so your suggestions are very valuable. Now I can continue with some questions. I've still got people here.
Thanks, David. We have a few more questions. All right, so the next one we have, there was talk previously of a blacklist for pirates who reoffend with preemptive filing. Is there any progress on this? And obviously the person has noted that it's quite a big task considering the volume of filers. Over to you guys.
The blacklist is something I've seen mentioned for the last couple of years.
It means that the TMO side has any blacklist against parental registrants. Yeah. In terms of the official, officially published or officially admitted blacklist, I believe none. There's no any officially published or officially recognized blacklist against parental registrants. Or practically, I think it's impossible because the number of them will be huge. So what we're doing in my practice or in our practice that we want to mention it with examiners, the people are doing something different. The applicant or registrant of this specific mark is not a normal one. This is an abnormal one. The people are registering this mark. What they have been done before is that they're registering a huge amount of marks, not only this brand, but a lot of famous brands along with. So we want to let the Chinese examiner know or Chinese judge know this. So if they know this in your by your evidence, there's more ratio of win in terms of your invalidation opposition by quoting, as I mentioned in my slides, by quoting the Article 4 and Article 44 in your invalidation proceeding or opposition proceeding. So this is very important. But you cannot really rely on an official blacklist issued and maintained by the Chinese officials. Then they can do take care of everything for you. This is almost impossible.
Thank you for that. Charles, we have a question for you, and it's with regards to scent marks. So the question is, I understand that the Chinese trademark law, Article 8, does not protect scent marks as they are updated to the Trademarks Act 1985, which has a provision hardly tested in Australian courts. Could you comment on that if you wouldn't mind?
Thank you for just a very, very interesting and very cutting-edge question, I have to say. The scent mark in China is still on the face of a theoretical. It has no any practical came to any case or any specific or application in China, because the trademark law of China currently, as I mentioned in my slides, it's just have admitted two kinds of. First is about the sign. So the visible thing, the visible sign can be registered. The second would be the sound mark or audible mark, but it has no any allowable or legitimate, legally admitted kind of mark on scent mark up to now, I believe. Yeah. And in the future, we don't know. We hope they have more openness on that. Yeah.
Thank you, Charles. So the next question we have through, the question says, I understand that there is no infringement for export given export does not constitute use in China, but mention was made that this is somewhat dependent on trademark registration in the country to which export is made. Is that understanding correct? And if so, what is required in the country to which export is made?
So this is on the OEM situation.
Okay.
So it was either the Pret or the Dongfeng case that the court was specifically considering the registration in the destination country, and because the exporter held the trademark in the destination country, they were found to be not infringing. I think the courts have been generally somewhat flexible in how they look at the OEM cases, which I think has been a good thing. I think if you start to put too many hard rules in what will and will not be considered infringement, it reduces the flexibility. So I think the courts have used flexibility in a good way, and they can fully consider the circumstances of each situation.
I very much agree with David that the Chinese court is adopting a very flexible approach against the OEM issue, which means that in very recent cases, in the last 4 to 5 years, first of all, you got to know that the Supreme People's Court in Beijing, the highest rank of the Chinese court system, that it has an inclination to allow the OEM products to be made in China and found it not infringing in a lot of cases in the last 5 years. And another issue is that they're taking into account about the registration status in destination country, destination harbor. In a lot of cases, some of the exported goods go to another court in another country in Pacific Islands or in other country. Then the Chinese court generally thinks that they got to see the evidence in the registration status of that. And they're really taking that into account when they're making the court decision. Surprised us, but it has done that in that way. Yeah. So what we want to remind brand owners that, first of all, if you have OEM in China yourself, then you have less concern than ever that if the people registering against your mark and sue you in Chinese court is a good thing. But the bad thing is that if you have your own registration in China and another infringement happened in China, then you possibly have more risk or have more difficulties in enforcing your trademark against them, because the possibility that they will claim that their products, infringing products, actually for exportation or 100% for exportation. And then they will quote this as a defensive arguments against you in Chinese court. So I have been working with a lot of foreign experts before, writing a lot of articles on that. A lot of them are actually opposing this new trend, is that it gave more weight to the Chinese infringers by quoting this. But Supreme Court seems to still be more favorable to the OEM manufacturers. And of course, they will examine a whole bunch of evidence to prove that the whole process of manufacturing and distributing is complete. So if you are a brand owner in China and then you are challenging an OEM manufacturer in China, so in the Chinese court, you've got to let the Chinese judge know that their evidence is not complete. Whether they have their manufacturer and exportation and destination harbor, what happened in destination harbor, this evidence should all come to your radar. Then you got to know all of them. Then this will, whether they have been proved as a 100% exportation or not, will be a very important question for you to fight against your OEM infringer in China.
And very interesting. It can go both ways with counterfeiters and infringers using it as a defense as well.
Thank you for that. So another OEM question. So is OEM manufacturing / branding in China sufficient to defend against a non-use cancellation? Is this different to the position with regard to infringement?
Very, very good question today.
We've been wondering that.
Actually, as far as I know, in the recent court rulings, court decisions in last 3 to 5 years, in general, the Beijing High Court, the final decision maker in the trademark validity, their general attitude is still that they will allow the OEM evidence to maintain the trademark registration against the challenger of 3 years, 9 years. This is their general attitude. We see a lot of contradiction in this, which means that on one hand, the court says OEM manufacturer is not infringing to another people's registration in China. But on the other hand, the Chinese court will say the OEM is sufficient to maintain the registration in China as evidence to prove the use of a trademark. So there's a contradiction. And as I mentioned with David last time, that there's more policy-oriented decisions, I believe, but there's impractical.
Yeah, useful, pragmatic flexibility. Use for the purpose of maintaining a registration, not use for the purpose of infringement.
Thank you, gentlemen. I've got a question about combination and device marks. So for combination/device marks, is it best to register as grayscale or for the colors or in the colors used? So the example in Australia, registration is one color is taken to be effective from all color combinations on specific limitations is recorded. Does that make sense to you, David and Charles?
The question is that register whether they want to register color or not. Is that
yeah, whether register it in color
or not.
Or in black and white.
Yeah, I think in general, what we're advising our clients is not to register the color. It's because the more factor you want to get into the registration, as I mentioned, the less or the narrower scope of protection you will obtain from the Chinese authority. So in general, the color marks only be registered when they really does not have other factors, like they do not have a shape, they do not have a device, type and a letter, then people want to register the color mark as a whole. But in most cases, the people want to get their black and white word mark, black and white device mark without any mentioning of the color. So this will get you the best protection and the largest scope of protection.
Yeah, so a little different to how it's treated in Australia.
Okay, thank you very much. So the next question I have is, where are marks such as Walmart in Class 35 retail mark overseas? In China, if it is registered for specific retail goods, what are the chances of the service mark being removed by a non-use cancellation action on the basis that it has not used its Walmart mark in relation to the goods that bear the brands of other manufacturers?
I'm not sure whether I got the whole point.
So I guess essentially, would Walmart be vulnerable to a non-use cancellation for its mark in Class 35?
Yeah.
Would its activities, its operations in China constitute use?
Right.
In Class 35?
Yeah, this is a very difficult question. Actually, as I mentioned in my slides today, that in terms of one suit case, as I mentioned, that judged by Beijing High Court, is that the Beijing High Court still maintains their attitude that a use of trademark in terms of retail services, supermarket services, this kind of services, does not mean that they will be able to use it as evidence to maintain their registration in Class 35. On the other side, is the question would be unsolved question would be the Chinese published list of classification does not have any specific services that's specifying on the retail service. There's an absence. None of them has been mentioned. So if you have a supermarket brand of a foreign brand owner, then you came to China. So what we understand that what they're currently doing in China is that they're trying to apply for every single or most subclasses in Class 35. And then the question would be whether this can be maintained or not. As I mentioned in the one suit case, this is questionable. is still be vulnerable when the people who filed 3 years, 9 years. So what they're doing is that possibly we can estimate is that they do the application every 3 years to maintain the brand and be valid. This is not this is the only way they can
temporary solution
in China. Yeah.
Thank you for that. A question with respect to copyright. Is the Chinese copyright registration effective to invalidate or oppose a competing trademark if the date of copyright publication predates the application for the competing mark has been filed or before it has been registered?
Thank you for the question. First of all, I want to mention is that possibly different from other common law countries. In China, any copyright registration in China is a formal thing, is a procedure thing rather than essential thing or legal thing, which means that if you have a copyright certificate issued mostly by China Copyright Protection Center affiliated with the Copyright Bureau of China, they will give you a certificate in the end of their application. But this is just as a prima facie evidence when you do the litigation in China against your infringer, which does not mean that you have already have the right in hand without any challenges. So when you go to the trial with the Chinese court will still review those cases or review those evidence or examine those evidence. So they will not just rely on one paper or certificate issued by Chinese Copyright Protection Center, but also want you to produce more evidence. For example, the trademark copyright law of China, as well as its relevant judicial interpretation, also give you more detailed requirement. For example, any draft of your copyrighted work can be a good evidence. Any assignment contract for the relevant copyrighted work can be a good evidence. Any other copyright registration in a foreign country can be a good evidence, and also any other trademark registration in another country can be a good evidence for you to prove your the ownership of your copyrighted work in China. So another question as you asked is about the relationship between the copyright and the trademark. As I mentioned, the trademark registration in China is way more important and way more lawful, protected, and recognized right than the copyright certificate. So the trademark is an officially granted right. It can be enforceable. It can be useful for against any infringing cases, and it's almost like unchallengeable in terms of civil litigation.
So
yeah.
So I think this. What about the situation where there is a trademark registration to a client's mark, a bad faith trademark registration? They can prove they have the copyright. It's a logo mark. They
right.
have ownership
right.
of the copyright.
Yeah.
So I think the question specifically about challenging the trademark registration on the basis of the copyright.
Yeah.
Would they need to have? Would the copyright registration need to predate the trademark application, or can they go through the copyright procedures afterwards and prove the ownership was earlier? The creation of the work was earlier.
Very good question. Yes, the short answer is that if you have evidence to prove that the copyrighted work you're relying on in your trademark proceedings, that the work is completed before the application of that trademark, then it's a valid evidence. For example, you have the evidence to prove that logo has been completed in Australia years ago, before the application date of the current disputed mark, then that will be a very valid and a very decisive evidence to challenge that trademark. In terms of the substance of that evidence, you may go to any publication in Australia, any publication in China for that work, and any registration, copyright registration you have already got in Australia. So And basically, you want to know is that both China and Australia is Berne Convention member state, if I'm not wrong. Then any copyrighted work you already got in China recognizing Australia would automatically allow you to be enforced in China as well. So that can be a good bridge for the people who want to use their copyright in Australia against the Chinese trademark.
Yeah, so evidence of the work, creation of the work at a prior date can be used.
Yeah.
Good afternoon, David, Charles, thank you. Is there any final words you want to add before we close out the session?
One thing is that I have my email address in the last slide. If you have any additional questions you still want to ask, feel free to email me at any time.
And my email address is also here. Feel free to get in touch with me on any individual inquiries, any issues you think worth addressing at the policy level, and any suggestions on future topics.